Kindly wait. I request all the participants to be on.
Ma'am, start the lesson.
Okay, yes.
Good morning, everyone.
A very good morning to Honorable Vice Chancellor, sir,
Good morning.
dignitaries,
Good morning.
faculty members, students. I request all the participants to be on mute. Thank you.
Good morning,
A very
ma'am.
good morning to Honorable Vice Chancellor, sir,
Yes, good
dignitaries,
morning.
faculty members, students, and all other participants. On behalf of the organizing committee, I welcome you all for the one-day national workshop on COVID-19 and its effect on intellectual property on the occasion of World Intellectual Property Day 2021, which is celebrated on 26th April every year. The event was established by the World Intellectual Property Organization, WIPO, in 2000 to raise awareness of how patents, copyrights, trademarks, and designs impact on daily life and to celebrate creativity and the contribution made by creators and innovators to the development of societies across the globe. For today, we have taken a topic with regard to the current pandemic situation, COVID-19 and its effects on intellectual property, which has been felt worldwide and across all business sectors too. This is also leaving an impact on the protection of existing IP rights and in the process of acquiring protection. Eminent speakers are with us today to make the workshop more interesting and useful for us. Now I request Dr. Sunil Gladson, sir, Assistant Professor, Department of Intellectual Property, to deliver the welcome address. Over to you, sir.
Yes, Aarti. Good morning to you all. I would like to welcome all the dignitaries and the participants in the virtual meet. First, I should thank to our Chancellor, Governor, because he followed our famous poet Thiruvalluvar. As Thirukural says, after having considered this man can accomplish, this by these means, let leave with him the discharge of that duty. Yes, our Honorable Vice Chancellor. I should first welcome to Honorable Vice Chancellor because Governor has selected a wonderful man, a man of accomplishment, and the architecture of Tamil Nadu legal education. He's really a game changer in legal education in the state of Tamil Nadu. And this is the first national virtual meeting after he assumed his office. So on behalf of our Intellectual Property Law Department, I welcome our Honorable Vice Chancellor, Dr. Santosh Kumar, sir. Welcome you, sir. Welcome.
Thank you so much. Thank you so much.
Thank you. And, we invited an eminent IP scholar, and he is also an author of IP books. He has attended various conferences, seminars, both nationally as well as internationally. And you know who is Dr. G.B. Reddy? His scintillating speech on various topics really mesmerized the gatherings. I was also witnessing some of his speech, which really sparked and ignited the minds of young scholars. So on behalf of our Vice Chancellor and our Intellectual Property Law Department, I welcome you, sir. I welcome Dr. G.B. Reddy, sir. Welcome you, sir. And next, I would like to welcome Mr. Gopakumar, who is from the state of Kerala, working in the Third World Network in New Delhi. He's a great IP scholar. And he published a lot of, very quality articles in various national as well as international journals. And this man who is working with pharmaceutical patent related subject matters, particularly Section 3D of Indian Patent Act, and relating to evergreening patent, all these aspects. So on behalf of our Vice Chancellor and our IP department, I welcome you, sir. I welcome to Mr. Gopakumar. The next speaker, Dr. Shaktivel, who had completed his LLM in Cochin University, Kerala, and who is also one of the young and energetic scholar in the field of intellectual property law. He has written various articles, both nationally as well as internationally, and who also participated in various conferences in India as well as abroad. So on behalf of our Honorable Vice Chancellor and our Department of Intellectual Property Law, I welcome you, sir. I welcome to Dr. Shaktivel, sir. Next, I would like to welcome Ms. Aarti Ashok, who is also an assistant professor in research from the Cochin University, Kerala. She is also an IP scholar, who is also one of the important speaker in this virtual meet. On behalf of our Vice Chancellor and on behalf of our IP department, I welcome you, ma'am. I welcome to Aarti Ashok. Next, I would like to welcome Binoy Kadavan, who is one of the leading IP practitioner in the state of Kerala, and who discussed various aspects of IP and who appeared for many litigations. It is very, very important aspect because he is a leading IP practitioner, one of the leading practitioner in India in respect of IP subject matters. So on behalf of our Vice Chancellor and our department, I welcome you, sir. And I would like to welcome our Honorable Registrar and the Director, School of Excellence UG, and the Director, School of Excellence PG, and our Controller of Examination, all the HODs of our university, and the Director, Research and Publication, and all the eminent teachers, all the eminent professors of Ambedkar Law University. And I would also like to welcome the young and energetic academician, one of the young and energetic academician in India, Dr. Reddy sir and Revati madam, and all my colleagues. And I also welcome all the participants of this virtual meet. And let us have a wonderful discussion on COVID and its effect on IP. Actually, IP will make a huge impact on COVID-19 because IP is a solution for this COVID-19 or this coronavirus. So we honestly believe that IP will give a wonderful solution for this coronavirus. So I should express thanks to this opportunity. Thank you. Thank you. Aarti, please go ahead.
Thank you for your warm welcome address, sir. Presidential address is by our Honorable Vice Chancellor, Professor Dr. N.S. Santosh Kumar, sir. Since this is the first program being organized after Honorable Vice Chancellor in office, I'd like to take few minutes to introduce our Honorable Vice Chancellor. Sir secured BL degree from Government Law College, Trichy, and ML degree from the famous Cochin University, Kerala. Sir has secured PhD degree from our university for the thesis International Acceptance of Alternative Dispute Resolution System with special reference to India. In the year 1988, Sir joined as a junior professor in Government Law College, Trichy, where he did his law degree, by which he has become alma mater of that institution. In the year 1997, Sir has been transferred to Government Law College, Tirunelveli. Sir has always dedicated his life for the students and their improvement in their life. He has been serving as chairman of Legal Aid Program throughout his service, through which he served many people to get back their lost rights, which was appreciated by judges, courts, colleges, and even by the general public. In the year 2011, Sir has been promoted and posted as principal in the Government Law College, Coimbatore. In Coimbatore, Sir secured a name as Reformist of Coimbatore Law College. Throughout his service in Coimbatore Law College, Sir was very strict with discipline and improved the academic flavor among the students, by which it has created an atmosphere that very next year in the counseling, the first 5 ranked students chose Coimbatore Law College as their first choice. In the year 2013, he was elevated as principal of the prestigious Madras Law College, where also he never compromised the discipline and set so many records in the education, including one of the very important thing is in Sir invited 17 High Court judges to the college who spoke on different subjects in that college within a short period of 6 months. Once again, Sir was promoted as Director of Legal Studies on 31st March 2014. During Sir's tenure, Sir has made tremendous changes in the department by which the student, teaching faculty, non-teaching faculties, and even government is very much satisfied with Sir's performance, and they felt very happy about his leadership in the department. As a mark of his dedicated service, the Tamil Nadu government appointed Sir as convener in the committee for discharging the powers of the Vice Chancellor of Dr. Ambedkar Law University in the year 2017. In the year 2018, Sir successfully appointed 174 assistant professors for the government law colleges across Tamil Nadu, which gave life to many young faculties, in turn helped the legal education. All this hard work and dedication, commitment has made Sir reach the Vice Chancellor position. We are very happy and proud to invite Honorable Vice Chancellor Sir to deliver the presidential address. Over to you, sir.
Thank you, Arti. Thank you, Arti.
Welcome, sir.
I tender apology to all the participants for bearing such a long introduction about me by Arti Ratna. If at all you need my horoscope, you can ask Dr. Arti Ratna. She will give such an extent, such a long introductory remarks she has made. I do not know whether I am worth to that. Anyhow, thank you very much. Very good morning to one and all joined in this national workshop on COVID-19 and its effect on intellectual properties. At the outset, I appreciate the organizers for conducting this workshop, especially on the eve of World Intellectual Property Day on April 26th. That too, during the corona second wave, which overpowered the people, spreading to compete the world countries as such. I sincerely thank Dr. G.B. Reddy, Professor of Law, Osmania University, Hyderabad, Dr. K.M. Gopakumar, Senior Researcher, Third World Network, New Delhi, Dr. M. Shaktivel, Assistant Professor, Guru Gobind Singh, Indraprastha University, Delhi, Ms. Aarti Ashok, Assistant Professor of School of Legal Studies, Quizat, Cochin, Binoy K. Kadava, Advocate, High Court, Ernakulam, for kind enough to accept our invitation and join with us in this great occasion. I'll be failing in my duty if I fail to thank our beloved teaching faculty members, Dr. Lucky George, Dr. Sunil Gladstone, Dr. Brinda, Ms. Aarti Ratna, Ms. Radhika, Ms. G.V. Mohana, and Mr. Jeffrey Andrew for their tireless work, which ended in a nice workshop on this issue. Actually speaking, it is a peculiar situation wherein we have decided to conduct this workshop. Dear ladies and gentlemen, this university, from the date of inception on 1997, never goes back from conducting any program, irrespective of any situation. To that extent, this evening onwards, around 200 students and teachers of this university will be on road for the period of 1 week to make awareness among the public about corona vaccine and the prevention of corona infection, especially when the people are developed a natural fear of coming out of home. Dear friends, today the global community is confounded with the COVID-19 pandemic. not only because a global health crisis affecting the human health, but also disrupting the economy, which in turn causing many people around the world to lose their livelihood. Therefore, the intellectual property rights gain significance at this moment. When it comes to the protection, access and distribution of vaccines and drugs against COVID-19, which is a prime challenge to the government in the national and international level to fight with the proliferation of virus. Agreement on trade-related aspects of intellectual property rights, the TRIPS, one of the agreements established by WTO, enforces binding obligation on member countries to ensure minimum level of protection of intellectual property rights in their territories. You all may be knowing that the member countries to the TRIPS agreement shall grant protection to the invention, both the product as well as process. In all the fields of technology, pharmaceutical patents can be granted to both the product and process, thereby ending the process of reverse engineering in pharmaceutical sector. Patent protection monopolizes the vaccines and drugs, and the patent holder has an exclusive right to manufacture, sell, and use the vaccine and drug for the period of 20 years. This right may lead to unaffordable vaccines and drugs in the market, affecting the health. Notwithstanding the impact of pharmaceutical patent on right to health, a well-organized industry aims to balance the public interest with the private interest, as that is one of the objectives of TRIPS agreement. The intellectual property protection and enforcement mechanism incentivize the technological innovation and transfer and dissemination of technology by rewarding the inventors, others, etc., with the access, facilitating the users to have access in certain circumstances.
We request the participants to be on mute. Participants, kindly be on mute.
As the host, you can mute other speakers.
Yes, madam, but we couldn't find who's speaking. It's popping up.
Yes, let us proceed. Let us proceed.
Yes, sir. Thank you.
Yes. Ladies and gentlemen, you are well aware that several flexibilities are also viable in TRIPS agreement to address public health exigencies. The government authorizes the third party to make use of a patent without consent of the patent holder during the term of patent by issuing compulsory licenses on certain grounds. Further, the government can use the patent for public, non-commercial purposes to augment the production of drugs in affordable prices. But the countries that lack manufacturing capabilities in pharmaceutical sector could not effectively make available this compulsory license. Dear friends, India, along with the South Africa, made a joint proposal at the World Trade Organization asking for temporary waiver of the implementation, application, and enforcement of certain provisions of TRIPS agreement, so that intellectual property rights on COVID-19 vaccine and drugs are waived for a limited period of time to ensure rapid scaling up of manufacturing of vaccines and ensuring accessibility and affordability of vaccines for all. This proposal has been supported by 46 member group under the developed countries. Further, India echoed in UN Assembly that vaccine inequity will defeat the collective global resolve to certain viruses, as the disparity in the accessibility of vaccine will affect the poorest nations most. So the world countries eagerly waiting for the decision of United Nations to take a decision on exceptional circumstances, as happened the year 2003 regarding the accessibility of medicines in the underdeveloped countries and other developing countries that lack manufacturing ability. The Doha Declaration on TRIPS and Public Health recognized in its paragraph 6 that the WTO members with insufficient or no manufacturing capabilities in pharmaceutical sector would face difficulties in making effective use of compulsory licensing under the TRIPS agreement. So, accordingly, WTO in its General Council adopted the decision to allow the countries to export drugs manufactured under the compulsory license to countries that lack manufacturing ability. Intellectual property rights, on one hand, plays a vital role in stimulating research and development, new innovations, which are the need of the hour. On the other hand, the TRIPS flexibilities prove insufficient in managing the current pandemic situation. It is imperative to understand the gravity of COVID-19 crisis, and the concerned parties should employ all the available innovation strategies in incentives to the mitigation of this crisis. So, dear ladies and gentlemen, like this, there are innumerable issues now emerged, which requires sympathetic consideration from UN, WTO, and even to the extent from developed countries, which I am leaving to this forum to identify and discuss in detail. With this short note, I wish all the participants to enrich with heavy knowledge on the subject matter and to appreciate the organizers once again for choosing this topic for discussion under this situation. I wish this workshop to get high success through meaningful discussion on this and related issues. Thank you. Thank you so much. All the best.
Thank you very much, sir, for the presidential address. It was a detailed one. Thank you very much, sir. Now, let's move on to the inaugural address. Inaugural address is by Dr. G.B. Reddy, sir. No law students needs an introduction about sir. We all have come across sir's book a lot in many areas, especially in intellectual property. Dr. G.B. Reddy, sir, is a lawyer turned academician, studied LLB and LLM Constitutional Law at Osmania University and PG Diploma in Human Rights from University of Hyderabad. Sir obtained PhD in law from Osmania University in the year 1999 on Supreme Court and judicial activism. Sir specialized in the area of intellectual property as an independent researcher, publisher, and teacher. Sir held almost all the academic positions in Faculty of Law in Osmania University, including Principal, Head of Department, Chairperson of Board of Studies in Law, and Dean Faculty of Law. Sir has authored 23 well-received books on law, including Women and Law, IP Rights and Law, Copyright Law, and so on. Sir has been a visiting faculty at several reputed institutions, including the State Judicial Academy, State Excise Academy, NCR, HRDI, CCRT, NAARM, and so on. Sir has participated in several national and international seminars, workshops, and conferences on law and allied subjects, and visited Malaysia, Singapore, South Korea, and Thailand. Sir has delivered more than 400 invited lectures on law and related topics. We are honored, sir. It's our privilege to have sir today with us. Over to you, sir.
Thank you, ma'am. A very good morning to all the dignitaries. Professor N.S. Santosh Kumar, Honorable Vice Chancellor, Tamil Nadu Dr. Ambedkar Law University. Professor K.M. Gopakumar, the learned resource person. Ms. R.P. Ashok, Dr. Shektived, and legal rights of the Department of Law, Ambedkar Law University, Professor Adil Reddy, Professor Revati, Professor R.K. Ratna, Dr. Sunil Blackson, and Dr. Lucky George, of course, and other colleagues and dear participants. I am extremely happy to be with you this morning on the occasion of the national workshop on COVID-19 and its impact on intellectual property, organized by the Department of Law of the prestigious Dr. Ambedkar Law University. Well, as all of you are aware, the intellectual property rights in the context of COVID have been receiving a mixed response from the world over. Whatever are the flexibilities under the intellectual property rights regimes have already been referred to by the Honorable Vice Chancellor in his inaugural address by referring to the relevant provisions of the TRIPS agreement and also under the national legislation of India. I would touch upon a few of those issues to be deliberated upon by the remaining the other resource persons. And one point is very clear: whether intellectual property is an opportunity or a challenge, as a tool to deal with the public health crisis on account of the COVID-19 pandemic is to be deliberated. One point is very clear: the fixed notion of intellectual property right being a private right may not be good during emergencies like this. Otherwise, we'll be very happy to respect rights and other rights in the context of intellectual property and the right to exploit commercially those rights by the different stakeholders. But this is the time to think about the public interest theory of protection of intellectual property and serve the public interest to meet the COVID-19 and
Sorry for the disturbance. Participants, kindly please be on mute. Darwin. Sorry participants. We'll check and do the needful.
Probably the host can mute all of us, then you just unmute Professor Reddy. Mute all the participants, please. Then we can unmute only Professor.
I think now it's okay. Can I continue? I think I will continue. There is silence. Right. Thank you. And I hear that I am audible. I was talking about the intellectual property rights and those challenges during the COVID, which the theme of this workshop analytically speaks about. And you may recollect that our national intellectual property policy of 2016 has one important objective, that is, knowledge owned is transformed into knowledge shared. Probably this is the time to deal with this particular objective. Whatever knowledge which is secured by certain stakeholders, now that must be used to fight the COVID-19 pandemic. whether by way of licensing, compulsory licensing, and by any other means we shall see. And at the same time, I am also, in fact, reminded of the given by the Honorable Prime Minister on the occasion of the Indian Science Congress last year, January, where he said, innovate, patent, produce, and prosper. Whether we prosper or not, but time has come to innovate. And this is possible by using the flexibilities under the IPR regime. Sometimes, as you know very well, international legal regime takes care of many aspects like the principle of national treatment, but when it comes to the national legislations regarding in fact, we treat them as private rights generally only with few exceptions. And we have fixed periods of protection. Then, the consolidated rights and obligations. But one thing is very clear in terms, including the Indian government, have really used the exceptions in intellectual property rights. This is equivalent to see the statistics from other countries. Today we are talking with alone and the extreme emergency, then compulsory licenses, acquisition of patents, acquisition of used by the government, talking about patent goods. America is talking about that is not applicable in the present context because that is only with regard to film. But that is in 1983. Otherwise, the fact is that we have in the intellectual property rights have not been invoked for various reasons. Indian IPR, more importantly, the patents regime, legal regime, is not oblivious to public health emergencies. Every student of patents knows that absolute freedom and absolute rights. And Section 47 of the Patents Act, every patent shall be subject to certain conditions. Conditions in class 1, Section 47 is very clear in respect of drugs. The book, it may be for distribution in any dispensary, hospital, or other this is one. Also is very clear. The purpose of enriching the patent pool of the owner of the company which is getting the patent. Section 83 clause D, it's categorically mentioned that patents granted. It's a philosophy, but that should be, in fact, guiding the governments of the day. Then when we come to the other licenses, of course, now I think 3 days back, many researchers are also insisting on issue of compulsory licenses. Let us see. But Section 84 of the Patents Act, which categorically encourages the controller of patents to grant licenses, only says there's 3 grounds. I think compulsory licenses. The case is laid out. Another aspect is Section 92. Good friends, who is speaking about filing a asking for a direction to the central government to issue compulsory license. Then I have my own saying that standard essential patents, SCP regime also could be invoked. In the case of issuing compulsory license. It's a new question. Point is very simple. There is a problem in the patent law which has to be limited. I'm talking about section 92, special provision for compulsory licenses or notifications by central government. Maybe you know, this is nothing short of emergency, extreme urgency. No doubt there are three, in fact, diseases which are mentioned here, but there is only inclusive. There is every possibility of including even the COVID-19 pandemic under Section 92 by issue of identification. Similarly, Section 92A of the Patents Act also gives enough flexibility to the government for issuing compulsory licenses for exporting of patented pharmaceutical products in certain exceptional circumstances. Maybe, COVID diplomacy is one of the essence of this. Section 27 speaks about parallel imports of patented medicines and drugs for merely of its own use. I'm saying this because I've had an occasion to go through some of the wonderful writings made by key researchers on pharma patents, including those by Dr. Gopinath. I had an occasion to go through his article in Colorado. What I'm finding now is that there is illegal hoarding and booking and reselling of the so-called life-saving drugs which are used to treat the COVID-19 by most of the economically developed countries. And now again, the same situation has come back. When the opponents of the product patent regime were talking loud voice during 1994-95. Probably it is a different position altogether, but certainly the developing countries, it's not India and South Africa alone, which are in fact fighting for this, but all the developing countries have been at the least developed countries. Now they are at the receiving end. This is one important point. I am referring to the defense industries of suit for insurance, acquisition of inventions and patents by the central government for its own use. It can be done. The question is, somebody might ask me, take the case of Covaxin drug, which is manufactured under a PPP, Public-Private Partnership Agreement. And now, Bharat Biotech, which is the Hyderabad-based company, then the ICMR, the government itself, they are partners in it. The question is very simple. How can the government really, in fact, violate its own terms of agreement, which are not meant to be? That is the point. There is an opacity as far as the kind of protection, the terms, because you read somewhere that Bharat Biotech is now negotiating with some US company for the purpose of producing the same drug there or maybe for the export. This is another important issue. But exactly are the consequences of COVID-19 pandemic touching upon the intellectual property sector. One is very simple. Today we are witnessing shortage of everything from quality masks to PPE kits. That is personal protective equipment kits, to diagnostic kits, to ventilators, and also other crucial medical equipment. This is a very sorry state of affairs. We are reading in the newspapers. Two sisters passed away within a span of 3 days. They couldn't get access to oxygen in Hyderabad. I read today morning. 5 hospitals. The 5th hospital had the bed and oxygen, but by the time the precious lives were lost. Second offshoot of this COVID pandemic is the increased research activity for vaccine. Lot of activities going on, but even clinical trial regimes are also not completely, in fact, followed. In the emergency and urgency, right? Clearances only after phase 3 of the trials, sometimes even after phase 2 of the trials. The vaccines are released into the market, but efficacy is not really scientifically probably not tested. And the results of the sample study, whatever it is, findings, they are also not in cases the research organizations are not sharing the complete data, which is a fact which we have to accept. Then there is an increased tendency to the indigenous medicines to treat COVID-19. Very unfortunately, Indians undermine their own capability and importance. Probably this is one sector where maybe PKD may not help us, but at the same time, certainly there must be some cure with regard to the COVID-19 the indigenous medicines. They're making many innovations and innovations which are mostly meat-based or centric. Few of them could be referred to. For example, Seattle-based US company called Slightly Robo. It has developed something called a hygiene smart band. And this is a wearable device on a wristband. It alerts immediately trying to touch the face. So because it comes only because of the touch. One. Second, there is another device developed by US-based company. It is temperature checker. This is an updated detection tool to track possession of ammunition by entrants in universities and caves, in especially places where number of people in fact access this can be used. Telemedicine is one of the offshoots. Online learning, video conferencing, e-commerce deliveries, then lot of demand for ventilators, face masks, and gloves. This is another aspect. Let's look at the developments in other countries. In fact, I will go through the COVID-19 tracker developed by WIPO, which is to be updated probably, but in majority of the 211 countries or so, or in the 60 countries, then, in fact, sentence is very clear. It says that the country has currently not granted any compulsory licenses, enabling the government to use problems, or made any changes to existing legislation in response to the COVID-19 pandemic. This is a common statement which is found in respect of the majority of the countries today. They are developing and least developed. But few exceptions could be made out. Probably there is something to learn from them. Chile, for example, on March 17, 2020, the Parliament approved a resolution requesting the government to declare that there were justification for granting of compulsory licenses on vaccines, drugs, diagnostics, supplies, and other technologies for the prevention of treatment of COVID-19. We don't require such regulations. We have enough problems in the Patents Act. And here, one wonderful thing is that on April 6, 2020, in fact, a group of these companies, pharma companies, they requested the cancellation of 6 of its patents related to drugs like Norvin and, Paletra, so on and so forth, with paving way for production of generic versions. So this is an initiative from the industry in other countries. In France, for example, in fact, on March 23rd March 2020, in order to combat the COVID-19 epidemic, it introduced a new article into the Public Health Code to give extraordinary powers to the French Prime Minister, enabling him to impose compulsory licenses where necessary, bypassing the general province. This is unusual because France was one of the worst hit countries you must have seen. Germany, for instance, in fact, there is an act for the protection of the population. The law itself reads like this: an act for the protection of the population in the event of an epidemic situation in national significance, 27th March 2020. Here, the Federal Ministry of Health was authorized to issue orders under a particular provision to, in fact, ensure that the public interest provisions are invoked and compulsory licenses are granted. This is another important aspect. Then, in other countries, Hungary, for example, new regulations were passed, like similar to Germany. USA, you have the first Federal Drug Administration issued emergency use authorization for investigation on antiviral drug remdesivir. This is one of the reasons why, in fact, we have the shortage. Even in India, I think that remdesivir is one of the most sought after drugs. Hetero, which is manufacturing it, is under constant pressure. Russia, for example, it issued an ordinance for compulsory license with regard to remdesivir in December 31st, on December 31st, 2020. And with regard to other, in fact, intellectual property rights, for example, with regard to copyright, MIT, that is Massachusetts Institute of Technology, now it is offering libraries free access. Then Harvard University, it is also doing the same thing under the Harvard University Library project. General Motors, in fact, it is in fact surrendering the design rights in respect of some of these, medical instruments designs. Then HP Enterprise, it has granted free access to all its patented technologies. So this is some kind of initiative from the different government organizations, multinational organizations, including international organizations like UNESCO. UNESCO also has come up with the, in fact, access to other resources. I'll take another 5 minutes, ma'am. Then what exactly are the strategies for future? Question is this: we are talking about a conflict between the private rights and also the public rights. And intellectual property, at one point of time, we used to think that it is a limitation on the human rights. But the authors and others say that it is a human right in itself. But is it, some of the debate? The point is very simple. There are a number of policy perspectives, strategies which can be used by all the stakeholders to fight this COVID-19 pandemic. So one is incentivization of the innovations and any other innovations leading to COVID-19. So startups, it is not sufficient to say it is, in fact, creating India, innovating India, so on and so forth. But there may be encouragement to the startups and individuals by providing investment. Investment only to maybe Serum Institute or the Bharat Biotech will not be sufficient. I think, they have to expand the base. Flexibility should be provided. From the administrative perspective, the procedures in these IP offices have been simplified to a great extent. There are other strategies. For example, even utility model and second-tier protection can also be explored to deal with the incentivization. Then, available problems like the CO. We are talking about compulsory license. The report shows that only one compulsory license for next hour has been granted long time back. After that, no, in fact, other company could succeed in obtaining CO from the government of India. So, acquisition by the government, parallel imports, then revitalizing Ayush and GRPK. Ayush, Department of Ayush, Ayurveda, Unani, Siddha and Hondo, then genetic resources and traditional knowledge. Which, in fact, not sufficient to portray India as a country of ancient wisdom. There is a need to annex on urgent basis the wisdom and the knowledge. Because nobody forgets the Doha Declaration on Public Health, 14th November 2011. Then again, I draw your attention to the judgment of the Delhi High Court, order of the Delhi High Court, not even judgment, in Rakesh Malhotra versus Government of Nation Capital Territory of India. That was on 20th, in fact, April, about 4 days back. Now, with regard to COVID-19, what exactly is the perception as far as the international relations are concerned? Just I'll take 1 or 2 minutes more. India and South Africa initiated a proposal to fold all the intellectual property rights which are recognized under the TRIPS agreement. And this proposal has been debated since October 2020. Many Indians are moving over the development role. Brazil deserted us. Brazil was sailing with us. Ultimately, one fine morning, it went along with other countries in opposing the using of the regime of intellectual property rights. And the opposition to this proposal came primarily from the developed countries being led by US or European Union, Canada, Switzerland, so on and so forth, on 3 grounds. One, they say that there is, if IP rights are forfeited or surrendered, it will be a disincentive to the innovation, especially for the pharma industry. Dr. Veerapanandi notes for it. The second one is there are enough flexibility in the TRIPS regime and also national legal regimes to take care of such situation. Third one is there is no shortage. If there is a shortage, how come hundreds and thousands of people are dying every day? I think they have to take evidence of this. Of course, I think we have to wait for the 12th Ministerial Conference of WTO scheduled in December 2021 in Geneva, which is rescheduled to debate all these issues. But one finding is that high-income countries with only 16% of the world's population, they have already reserved 60% of the available doses of vaccines and other medicines. Then what about the, remaining 84% of the world population? Where should they go? This is one question, right? And there is every possibility of managing with the existing IPR systems, like, obtaining multiple patents in respect of the same invention on various aspects by invoking the emergency provisions is another important aspect. I just draw your attention to one or two sentences made in the order of, included in the order of the Delhi High Court. In Rakesh Malhotra's case, two paragraphs are important, para 27 and 28. And the court categorically says there are a number of other drugs which are being used for treatment of COVID-19 patients, such as tocilizumab, then favipiravir, then, so dexamethasone. It's very difficult to pronounce them. Point is very simple. Most of them are hoarded. There is no possibility of getting access to them. Therefore, in fact, the Delhi High Court categorically says that the lives of the people take priority over everything else. Even if such powers are exercised, patent holders, manufacturers can be adequately compensated by fixation of fair license fees. I don't know whether government is in a position to dictate terms to the industry. That's another one. Now, be that as it may, to conclude, what I would say is that COVID-19 pandemic has thrown many new challenges as far as the purpose of intellectual property rights protection and the need to balance the private interest and protected rights. And there are a number of indications which show that governments are indifferent, at least on certain occasions, whether which is regarding the vaccine production, distribution, allocation, budget pricing. Just you see, Covaxin or Covishield may not be available at the same price to the central government, to the state government, and also to the private sector. At least, we can understand higher price for the private sector, private circulation and sale, but you can't justify the different pricing for the central government and state government. Something, which is atrocious. Then similar apprehensions are regarding the oxygen, because it is almost like interstate water disputes, where the one state having the advantage will not be in a position to release water to the other states. Similar case with oxygen. There will be oxygen battles in future. Then, on the end, there appears to be a larger conspiracy on the part of pharma companies all over the world. It's a global conspiracy. I think it has to be probed further. But within our limitations, the government can use even DPCO, drug price control order, to whatever extent it is applicable with regard to those drugs which can help in fighting the COVID-19 pandemic. But at the same time, this is not the time for confrontation. We sincerely hope that the central government and the state governments will act in tandem and will uphold the spirit of cooperative federalism as far as the protection of public health is concerned, without having regard to undue enrichment of the pharma companies, and at the same time, the big brother attitude of the central government over the states. So these are my few stray thoughts on this important aspect. I'm very much thankful to the organizers for giving me this wonderful opportunity. Once again, my gratitude to Honorable Vice Chancellor and all the respected colleagues from the law department, and I thank you for a very patient hearing. I thank you very much.
Thank you, sir. Thank you for sharing with us your in-depth knowledge in intellectual property and the current position of COVID vaccines, and giving valuable suggestions to combat pandemic through IP wholesale licensing. We regret for the inconvenience caused, sir. Thanks for being with us today and enrich our participants, enrich the session. Thank you so much. Dear participants, we request you all to be on mute mode, because even if at all we give mute all to everyone, what the people who are using devices which doesn't support the system mute all cannot be muted. So I request once again all the participants to check your devices, laptops, mobile, to check once again that whether you are in mute or not. It was highly disturbing when such renowned speakers are participating, you are disturbing all others also. So I request all the participants to check your devices and make sure that you are in mute mode. Thank you. We request your cooperation till the end of the session. Next, we'll move on to the keynote address. Keynote address is by Dr. K.M. Gopakumar sir. Sir is a senior researcher with the Third World Network, TWN. It's an independent, non-profit research organization that carries out policy research and advocacy on issues around trade and development, with a focus on third world countries. Sir is a very renowned speaker. It's our honor and privilege to have Sir for the today's session. Over to you, sir. Thanks for being with us today.
Thank you, Arti. Dear BZ, Professor Reddy, my fellow panelists and friends. So let me start with thanking the organizers for choosing this topic. This is at the right time where the country is facing the second wave of COVID, and we are realizing the scarcity of many of the health products. The inventories are struggling to cope up with the ever-growing demand. So having said this, let me start by two very broad remark on the intellectual property in the context of COVID. First, we were told that intellectual property is a necessity to basically recoup the investment of R&D. Without intellectual property protection, you will not have enough investment in the health products R&D, and therefore this is a necessary evil. At the same time, the critic pointed out that intellectual property related incentives will never work for those products which are of kind of prone to market failure, and it was true. Though there was a breakout of SARS in 2000, early 2000, but nobody invested in R&D. The private sector failed to invest in R&D. Then the investment started coming in only after the breakout of COVID. Kind of research started coming in. And interestingly, all these research finance came from the public sector. So the one estimation, the latest estimation is that around $100 billion were spent by the various governments or the public sector to boost the research and development. So that shows if there is enough funding, if the governments can play a crucial role in the development of development of health products, various health products required for the community. But at the same time, we also understood earlier that the best way to ensure access and innovation is through delinking the price of the commodity from the cost of R&D. Therefore, you can liberate the products and make it widely available. But the COVID also shows us that even after having huge public investment, the companies as well as the developed countries are not ready to give up the monopoly. So the problem is not in the protection of investment, or problem is not not there in the kind of financing, but the problem is of control, and this is essentially a political problem rather than an economic problem. So that is what we are realizing. And at the same time, as I said, this also shows that on a mission mode with a sufficient funding, you can have the innovation and you can push the product really into the market. Okay, so this is the first remarks on IP and in the context of COVID. And the second remark is that we also realize that normally the intellectual property and access to medicine discourses or discussions are focused on are generally focused on patents. So there is tens and tens of literature on it. But now we realize that it's not the patent alone. There could be any intellectual property protection can come on the way of public health. From a public health perspective, and copyright is problematic. When the public health perspective, trade secret is a big problem. I think it's more dangerous than the patent. I'll explain to you in a few minutes that issue. So therefore, we need to have a much more holistic understanding of intellectual property rights in the context of public health. So having said, having made these broad two remarks, let me now move to the focus of my topic. I would like to focus on intellectual property and vaccines, access to vaccines. Vaccine is generally termed, the COVID-19 vaccines are termed as a global public good. Many political leaders, including the UN Secretary General, termed it as a global public good. The last year's World Health Assembly resolution termed vaccination as a public good. Okay, please mind that. Vaccination as a public good, not vaccine. But still, all these political leaders, they never minced a word, and they said, if there is a vaccine, that would be treated as a global public good. As all of us knows that public good means it's a non-frivolous, non-exclusive. This is the standard definition. But I would like to view the vaccine as a public good from a slightly different angle. This is a vaccine which is financed by taxpayers' money. It's use the public money, and it should be available free or accessible and available to all the needy people. Okay, that perspective, it's a public good, and this argument is justified from economic point of view as well as from a public health perspective. From an economic perspective, we need to restart our economy or reboot our economy or bring back our economy to normalcy. How can you do that? We need to um, uh, normalize our economic activity. This can be done only when people can come back to their workplaces safely. So only way to bring back these people to workplace is that through vaccination. Vaccination here, there's a point of caution. All these vaccine developed till date is not capable to prevent the infection. It provides you a system immunity. Okay, so it never prevents an infection. So, but the advantage of this vaccine is that it will cut the severity of the disease or infection. As a result, you don't have to go to the hospital. It will be a mild infection for you. So therefore, the value of vaccine lies here. Have a problem of large number of people ending up hospitals or in ICUs. So after all, the health system can withstand the pressure of the pandemic. Second point for a vaccination is from a public health perspective. The public health perspective says that if you have the vaccination, as I already mentioned, that it brings the pressure on the public health system. There will be less hospitalization, there will be less severity, and that can bring sort of break the chain of infection. And the vaccine, though it is not meant for infection, but it also has the potential to prevent the spread of infection. So therefore, it makes sense to have a massive vaccination. And this vaccination should be available to everyone. So if you have a policy which may directly or indirectly prevent people from vaccination, accessing the vaccine, then your efforts will fail. Why? The point is very clear. Nobody is safe until everybody is safe. If people, a section of the people who cannot access the vaccine, then there is a chance of the virus spreading there, and then they get mutated, and then it can it can undermine the very objective of vaccination. So from these two perspectives, it is important that vaccine is available at an affordable price, or governments should make it available free of cost, if not at an affordable price. So from a physical policy perspective, therefore, it is worth spending on vaccine because it makes sense, because it will result in people to come back to the economic activities and bring back economic prosperity or welfare in a short span of time. So this is the only intervention we have. So therefore, it makes sense, and therefore the government of India, I think the last budget announced around 35,000 crores for national vaccination program. But let us see how that allocation will be spent in the coming days. So having said this now, therefore, it makes a good sense to make this vaccine available at an affordable price, or to ensure the vaccination at a shorter span of time to the largest possible percentage of the population. So a country like India need at least 70% of coverage, population coverage of the vaccine. So that means around 100 crores plus. So we have around 135 crores people. So that means in terms of dosages, if you're using 2 doses per person, you need at least 200 crores. So that takes me to the next point. If you look at that from that perspective, though India ranks third among the countries who had largest administration of vaccine, our population coverage not even reached 3%. That means the people who obtained 2 doses of vaccine. But India is not an exception. In every country, the vaccination is going in a very slow pace. Okay, except maybe US, which has around 34 crores people, and they started very early. Then China, then followed by India. And if you look at the global data, except these 4 places, US, China, India, and EU put together, but there are EU countries who do not have access to vaccine at all in many countries. Okay? So this constitute the around 57 crores or 60 crores of global vaccination out of 84 or 85 crores of doses administered till now. These 4 places, geographical locations, account for around 57 to 58 crores. So that means there is a large concentration of vaccination happening. It is very concentrated in a few places. So this will not yield the result. So we need access to the vaccine to all. So that can happen only when there is the product is available, and we are also aware that there is a shortage of vaccine. This shortage is emanating primarily from a fact that there are only a few vaccine manufacturers who are producing COVID vaccine. There are 12 vaccines approved right now. Out of that, the doses which are coming is less than promised. Around around September 2020, the doses promised was around 1.3 billion or 1.5 billion doses promised, by end of March. But we know that only 4% of that doses actually came into the market. So therefore, there is an urgent need to scale up the vaccine, and there should be a diversification of manufacturing base of this. All the COVID vaccine, if you view it as a public good, it should be produced by anybody who would be able to produce a quality vaccine. So here comes the issue of monopoly and concentration. This monopoly and concentration, in a way, incapacitates our nation states to fulfill their international human rights obligations or constitutional obligations to the people. So as a legal scholars, the problem lies, there is a human rights obligations, there are constitutional obligations, but countries or the nation states are not in a position to fulfill that obligation. That's things in a way beyond their control. The primary reason for that is the concentration and monopoly of vaccine. So what's the reason for this monopolization of vaccine? Intellectual property is the primary reason for the monopoly of vaccine. As we all know that the pharmaceutical companies uses intellectual property rights and the regulatory framework to control or to manage the competition. But many of the things the regulatory agencies uses actually indirectly linked to intellectual property rights. So let us take the case of vaccine. Vaccine are generally protected through two types of intellectual property rights, patents and trade secret. You look at technology, except one, all other already existing products are already, the technology platform we use to produce many other vaccines. The mRNA technology, that is the latest technology. That's the first time a vaccine using the
Sir, we cannot hear you, sir. You are on mute, sir. Just now, just few seconds
okay,
back.
okay. Oh, I think my finger touched or something. Can you hear me?
Yes.
No. So,
Yeah, now we can hear you.
so what I'm saying is that all these technologies are available earlier, okay, except mRNA technology. mRNA technology is the new technology, but at the same time, scientists will tell you this technology is around the world since early 2010 onwards. Okay, so this scientists, from a scientist perspective, this technology is not a new technology, but the product is a new product. There are many patents. There are around 200 or 400 patent families are involved in mRNA technology. I would like to suggest to read the article came in the IP Watch recently on the mRNA patenting of mRNA technology. Probably after the lecture, I can even share on the chat, looking at the patent families of mRNA technology. But as far as patent is concerned, you can always issue a compulsory license. Then you can create the freedom of operation. And the technological, the vaccine companies in the developing world, like India, they are capable of replicating the technology without the help of the originator companies. Therefore, we don't need their help to technologically replicate the technology. But the problem is actually in the regulatory front, because the moment you replicate the technology without the help of the originator, you will be asked to prove the safety and efficacy of the product which you developed. Such a burden is not there on a generic medicine manufacturer. For example, if you produce a remdesivir, you don't have to show the safety and efficacy of that medicine, because that is already with the regulatory agencies. So they will, if you are following the good manufacturing practice, you don't have to follow the manufacturing practice of the originator. Still, you have to prove only one thing, that the remdesivir you are producing is a remdesivir which is already approved by the regulatory agency. Okay, that's all. But when it comes to biologics, there are biotherapeutics and vaccine. Let me just focus on vaccine. When it comes to vaccines, if you are not following the manufacturing process of the originator, then you have a burden of proving safety and efficacy through clinical and non-clinical studies. Clinical studies means clinical trials. So you are treated as exactly like an originator. Maybe here and there, a few exceptions, you may get it, okay? But essentially, you are treating like as an originator. As a result, you have to invest money for clinical studies, plus it is time consuming. So this will delay the introduction of vaccines in the market. So this will also delay the competition in the market. And if at all the product comes in, It will not be as cheap like a generic medicine. Normally, you know that generic medicine can be introduced around 90% cheaper, and when you achieve the process efficiency, it may go down like 99% cheaper than the originator price. So that's possible, but in the case of vaccine, this is the problem. So here comes, without the assistance of the originator, you cannot have a speedy introduction of a vaccine by a non-originator company. So what is exactly why the non-originator is not getting the manufacturing process of the regulatory of the vaccine technology? Because it is protected as trade secret. There are layer of trade secret protection in the vaccine manufacturing, starting with the cell line, the details of the cell line, or the manufacturing processes, even the dosages, even some of the other details. So there are around 4 to 5 types of things are being protected through the trade secret. Since it's a trade secret, it is impossible to obtain access these information. So as a result, the non-originator is forced to depend upon the originator companies. But having said this, please also keep in mind that these non-originator companies are technologically capable to discern the technology without the help of the originator. They can understand the technology, they can replicate it. But when you do that, the regulatory agencies does not recognize that. They will ask you to prove the safety and efficacy. So in a way, our regulatory system acting as an enforcing agency for the trade secret. But from an intellectual property law, trade secret protection ends if the firm or an individual can discern the technology without using illegal means. That means not poaching a labor or a scientist from the originator company, breaking the non-disclosure agreement, or hacking the computer or something. All those illegal means, if you are not using, you are absolutely at the right side of the law to discern the technology through using your own technological capabilities. That is the way of looking at the designing of the technology or reverse engineering policy space for the non-originator company from a trade secret law perspective. But that is not the the norms followed by the regulatory agencies. Regulatory agencies looking at the only one thing, that whether you obtain the technology from the originator. Then you can do a stability study and introduce your product at the earliest. If you are not obtaining it from the originator, then you have a burden to prove safety and efficacy. So we need to reform our regulatory system and preventing the regulatory agencies from the enforcement agency of the trade secret. And so we need two prong actions to ensure the competition in the market through the scaling up of diversification of the manufacturing base. The first action is that, as I told you, regulatory reform. Prevent the regulatory agency as a enforcement agency of trade secret. Second, how do you ask, or how do you make this trade secret in the public, put it in the public domain to facilitate the scaling up of the production? In patent, as I told you, there is a compulsory licensing mechanism. Here, we don't have a compulsory licensing mechanism for trade secret, but trade secret has an exception. Okay, if you look at the US law on trade secret, or if you look at the European directive on trade secret, public interest is recognized as an exception to the trade secret protection. And the US FTC every year on IP and mergers and acquisition cases, they forces the one of these entities to share the trade secret. So that's possible. So here, how do you do that? The easiest way to do is that allowing the regulatory agencies to disclose the regulatory dossier to a company which is interested to produce this particular vaccine. So the regulatory dossiers contain a lot of information. Of course, there can be exceptions because companies may not give all information to the regulatory agencies in developing countries. But I think regulatory agencies like India receives a lot of information. So that way you can actually give this information. If the company is not ready to share that information to a potential manufacturer, the regulatory agency can give that information. So now regulatory agencies does not do that, or the agencies do not do that because they are afraid of Article 39.3 of the TRIPS agreement. Even though 39.3 provides a exception, you can share the technology, you can share the dossiers or share the information, disclose the information to protect the public. But we don't know the scope of the meaning of the word protect the public. Whether it is protecting the public is equivalent to sharing the dossier with a company which is going to produce the product and competing with the originator. Because the 39.3 also says that whenever you are free to disclose the information, but the moment you disclose, you should take steps against unfair commercial use. So this creates a legal uncertainty. This legal uncertainty creates a chilling effect on the regulatory agencies to share the dossiers. So here comes the waiver proposal. The value of the waiver proposal. Waiver proposal includes waiving of trade secret. So if the waiver proposal get adopted, then that in a way allows the regulatory agencies in various parts of the world or the countries like India can share the dossier with the potential manufacturers and contribute to the scaling up of the production. So that takes me to my final point. That's in our situation, as I told you, you need around 200 crores of dosages. Okay. Now, currently we are facing a duopoly, vaccine duopoly. Only two companies are producing it. Okay. They are not able to produce 200 crores by the end of this year. Okay. We, as I told, vaccinate people in great speed, right? Hit hard, hit quick, and hit maximum. So that should be our strategy. Okay. If you look at that, that's not possible. So that means we need more doses of vaccine. Of course, there are 7 companies, Indian companies, obtained license from Sputnik. But again, the regulatory rules prevent them starting the manufacturing. They have to do a bridging studies, or they are negotiating how it can be waived or how it can be minimized. So that all will take time. But at the same time, it also offers a possibility, that is the Covaxin. Covaxin is an Indian technology, which is, as a government of India has a share in that technology. Government of India already took a step to allow the 3 public sector units to produce this vaccine, maybe in the current production is not enough. And a country like India also need to supply. There are many developing countries who are depending upon India, and India took pride in the past, like it's a pharmacy of the poor world. And this is the time you have to produce and you have to supply. For that,
Sir,
vaccine technology to as many as many more companies, so they can scale up the production. This license can be given to Indian companies and companies in the other countries. So that way, you can set a new global order of technology sharing of vaccines. So that will keep put pressure on other vaccine manufacturers or other countries to do the same. So that way, we can resolve we can put some pressure on the scaling up of vaccine. The negotiations are going well. There are pressure on US to change, US to lead from the front as a global leader, as a moral leader. They should take the stand and they should support the waiver. And there are 400 European member of parliamentarians supported the waiver proposal. So the waiver is moving towards the right direction. In the coming days, there might be waiver, but I'm saying that countries like India need not wait the adoption of the waiver, and this is the time to exercise your legal rights and your sovereign right to protect the people. And before ending, I'll end with a small request. The country is facing a major uh, COVID outbreak, and we are facing a scarcity of various medical products. At least 2-3 such products are protected through IP. That's our small molecules like remdesivir and favipiravir, and biologics like tocilizumab. These are all protected through patents, and only a few manufacturers are here. I think as a IP scholars, we should intervene in this and should set, at least prepare and send a memo to the government that why government should use the flexibilities existing in the our Patents Act, as well as licensing of more vaccine manufacturers. This is not protected through IP, and this is a technology partly owned by the government, and make the COVID medical products as really a public good at an affordable price, and to achieve the public health goal of vaccinating as well as providing healthcare for COVID affected people at the earliest. Thank you.
Thank you for the keynote address, sir. Thank you for, you made the session very interesting, and the importance of availability of vaccines for the needy by discussing the importance and the monopolization of vaccinations, patents and trade secrets, protection involved in vaccinations, and mRNA technology, and also about the compulsory license. And the reason, that is the reason for the delay, and about generic medicines, and practicality in access to medicine, and also the importance of giving access to many pharma companies to produce vaccines in large number to combat the situation. We hope the session was very much useful and helpful for all the participants here. Thanks a lot for being with us today, sir. Next, we'll move on to the next speaker. Today, we have Dr. M. Shaktivel, sir, as a speaker one. Sir is an assistant professor of law at the Guru Gobind Singh Indraprastha University, New Delhi. Sir has graduated in law from Tamil Nadu Dr. Ambedkar Law University, Chennai, and completed his post-graduation with specialization in IPR and environmental laws from the School of Legal Studies, QSAT, Kerala, and conferred with doctoral degree from the IUCIPRS, QSAT, under the guidance of Professor N.S. Gopalakrishnan. So his book titled Broadcasters' Rights in the Digital Era, Copyright Concerns on Live Streaming has been published by Brill Nigboff. Publications on IPR issues ranging from webcasters' protections in copyright broadcast rights, copyrightability of sports contents, patentability standards with special reference to pharmaceuticals to industrial designs, renowned national and international law journals published by elsewhere, Sweet and Maxwell, Thomson Reuters, and Indian Law Institute, etc., add to its credit. Sir has presented his research paper in reputed international conference held at various countries. Sir is the recipient of the Young Asian IP Scholar Award from the Singapore Management University. Sir is a visiting faculty at Indian Law Institute, New Delhi, and is currently a visiting faculty at National Institute of Criminology and Forensic Science, New Delhi. Sir has been delivering lectures on various IPR issues at various training programs for judges, senior police officers, education institutions, and PSUs on IPR issues. We are very happy to have you today, sir. Over to you, sir. Sir, please.
Thank you, ma'am. Could you please enable me to share the screen? Thank you, ma'am. I hope my screen is visible.
Yes, sir, your screen is.
Good afternoon, one and all. I thank the TNDLU and the organizing team for inviting me for this wonderful session. Of course, Gopa is known for delivering such an excellent insights. And what we heard so far is completely on the access to medicine and the drugs. And now I'm trying to take you out of this access to medicine and moving towards entertainment industry related issue. And of course, on request, this topic has been, chosen. Of course, this is the topic on which I did my PhD, and the book is on the same aspect. So I'll be providing certain insights in this. Live streaming, author's right versus broadcaster's right. Yes, of course, I'm also part of, I was in Government Law College, Trichy. I was a student and studied there, and of course, graduated from this. I'm really proud of, delivering a lecture in TNDL workshop. Okay. Have we ever thought of meeting through this platform prior to 2020 March? Did you have any idea? I do recall in 2019, Feb 2019, we had a workshop in Cochin University IPR Center, in which Professor David Nimmer was supposed to participate. He couldn't come because of certain health issues in the family. So he participated in the event through Skype. We had great difficulties to bring him in, in the picture, and there were so many technical glitches. And it was not at all visualized. Then few people here and there, they started having this online sessions, but it was not at full swing. We did not think of this type of, having online sessions, but now it has become reality. Where you are sitting in your place, I am sitting in my place, but we are meeting. This is happening in a real time. This is what the live streaming is all, right? Have you ever thought of this? A full cinema theater is completely empty. Some time back, it was closed, then it was opened in a social distancing manner. Now, this has been closed. Have you ever thought cinema theater would be closed and there won't be any movie shown? We did not think. Have you ever thought these movies are getting released in OTT platform alone at first? Of course, we know Vishwarupam was was planned to be released only in OTT, but industry was facing huge problem. But there was no such attempt happened. Now all the movies are released either exclusively on OTT or OTT at first, then in theaters or parallelly. Have you ever thought of this type of event happening without any audience? In history, it was no. So now this is happening. They are playing. To whom they are playing? For us? To entertain us? So where are we? We are sitting in our home and we are enjoying it. Have you ever thought of these are the technologies going to be in the market down the line next 20 years? Look at the technologies that have been predicted, the forecast. And you have the indicators given at the bottom. And look at this 2010 to 2020. The video conference is given at the top in yellow color, and entertainment is also given in orange. You can see it was predicted on the left-hand side bar is an indication of experts' confidence. The level of confidence is there a 75 to 80%. It was at the peak, somewhere 2010 to 2011-12 period. Now it is at the momentum. Even this virtual education was also predicted somewhere at 2017, but it has taken 3 more years down the line. That too because of COVID-19. It has become a reality. Have you ever thought of these are all the social change which we will be facing? We did not, right? So similarly, the internet-based transmissions are also coming at the peak, and they are at the momentum right now. Now, the entire presentation is based on this particular aspect. Copyright and technology is not a odd. They are closely together and associated, right from the printing press. It can be phonogram, or it can be a radio or television, or it can be a mobile or computer or internet. Whatever may be the technology, whatever may be the nature, these are all the factors are closely connected with copyright. If there is any development, and that is having a positive impact on the copyright regime as well. So copyright and technology inseparable, complement each other. Exploitation of the copyright works through public performance was in the history. Publicly, you need to perform and people will gather at one place. It's like a stage performances. The technological evolution made people to sit in their home comfortably to enjoy the entertainment contents, and then led to the development of the communication to the public concept globally. So expansion of the communication to public to incorporate the radio broadcasting, the television broadcasting happened through the Berne revisions. The 1980 revision and 1948 revisions. It required huge investment for the infrastructure creation for the broadcasting industries to set up the broadcasting stations in the past to enable the copyright works getting disseminated to the public, thereby people enjoy the entertainment content and stay happy at their home. Prior to the introduction of the radio broadcasting, people had to gather at a particular place to enjoy a particular music. It was only phonogram records. Phonogram are the music sheets, which was not possible for everyone to be purchased. But it was a radio which was penetrating at the higher level in many countries. But the speed in which it penetrated into the developing world was substantially slow. So in 1900, it was at the peak in the United States, though radio was introduced in the UK at first commercially, but it was the US which brought the litigation. The competitors started pirating the signal at the initial stage, then led to the revenue loss of the radio broadcasters. So then people slowly realized that the author's right of broadcasting, the communication to the public right, which was conferred by the Berne, could not tackle the signal piracy because people or the competitors were pirating the signal and showing it in their stations, which was considered as a leeway in the copyright regime. It had to be taken up because signal is a technical component. The technical component can't be addressed within the copyright regime because copyright is only meant for protecting the creativity. The creative work is already protected. Now you are expecting the signal to be protected. Sorry, signal is not the subject matter of copyright. So that's the concern which the international community had. This leeway had to be addressed, which forced the international community to deliberate further, which paved way for the emergence of neighboring rights through the Rome Convention 1961. You all aware, the subsequent slides will give certain insights about that. And the later TRIPS agreement recognizes in the broadcasters protection in a limited way, which is understood that either you give it to the authors or you provide a neighboring rights model of protection in a limited way. And we are in 2021, we find the broadcasters protection remains constant since 1961, whereas there are plenty of technological advancements, including signal encryption techniques happen. As far as the digital broadcasting is concerned, it flourished and reduced the risk of piracy throughout the globe. People have switched over, including Indian subcontinent. Advent of peer-to-peer internet file transfer further simplified the entire process. So, you know, if you are 80s or 90s or the 70s, you must have experienced this. The HTML file downloading. I do recall when, I was in the hostel, Cochin University hostel. We used to have a one internet connection being shared by around 8 to 10 students. We'll be putting a one particular file to be downloaded. It will be taking roughly of 13 to 18 hours or 20 hours time. Now we have high-speed internet connection. So big audio or a video file is getting downloaded, and downloading is the entire file is getting downloaded for the enjoyment. That time the YouTube was not so familiar. Now YouTube is much familiar to all of us. People were not ready to put the entertainment content at open access model in the past. Now people started putting it up. The Cuckoo song is Enjai Enjami song is a typical illustration, or you have the other song of Rowdy Baby song can be the other one. People have been enjoying, repeatedly watching it. My daughter used to enjoy it around roughly of minimum of 5 times in a day. So smart TV connected with internet, it's providing the facility. But initially it was not. You need to download the entire file into your system. Then you will be sharing with your friend through a pen drive or a CD or DVD. It was that period. The entire picture is in the clockwise rotation. You could see how the file is to be downloaded from internet, and that will come into your drive, your storage device. It appears to be 4 slides. It's a very, very complex and time-consuming process. You need to have internet download manager. IDM was essentially required that period of time. Slowly, to overcome these difficulties, people started inventing this peer-to-peer model. Appears to be old. It's so effective in today's scenario. The Napster was the one illustration. The file has been dissected into small pieces, so you don't have to download the large files. Now, I am sure you all must be using the torrent one. So if you are familiar with torrent, this is nothing but it's the torrent model of this. But when it comes to the 4th generation peer-to-peer live streaming, it is like a television. You don't have to download at all. Just you spare your internet and the file will be appearing on your screen. You don't have to download. That's the trick in which the modern devices and the gadgets are being introduced in the market. With less storage, and you can have cloud storage if you want, or you buy with larger storage for which you need to pay heavy price. So that's the basic techniques on which the movement is all about. In the live streaming, you don't have to download the file. It's like in a simple sense, if I have to say, it is like a television. You don't have to download the file. Just you switch it on and whatever you want, you can. If you choose it, then it is going to be on demand. If you select the content, if you select the time, if you select the place, then it becomes on demand streaming. The presentation is not about on demand. It's only about the live streaming. So if it is a live streaming, just like a budget presentation, just like a cricket match happening, or a football match happening, or an entertainment reality show happening, that is the subject matter of this particular domain. So the internet transmissions, the streaming or live streaming or real-time streaming, because live streaming is referring to an event happening live. The real-time streaming is, no, it's a stored content, but it is being shown to all at the real time, and one time fixed by the service provider to all. That's the subject matter. From the end user's point of view, the live streaming appears to be the one and same with television, like television only. But the traditional, because of this factor, the traditional broadcasters demand, the broadcast reproduction right as given in section 37 of the copyright, as we understand at the international level neighboring right model, should be extended to the computer networks too. This aspect has been getting discussed more than 21 years. So 20 plus years of discussion happening at WIPO on this particular issue. So then we need to ask the question, should the broadcaster's protection be extended? So if I have to put it in a very funny manner, in Friends movie, the Vadivelu character, the Nesamani character will be asked, Ndaniya Pudungunuma, Ade Marda. So whether this broadcaster's protection should be extended in the internet context. The technological analysis part, when we examine the technology for the purpose of understanding to extend the broadcaster's protection, the radio, television, cable or satellite, the broadcasting, yes, they are broadcasting. In the cluster based, it's a signal based, the transmission one. I'm providing a summary, but these are all based on the huge, the technological analysis. Every bulletin point represents at least a good number of, 15 to 20 pages. Some, discussion are there in the back. So piracy of signal is quite possible. When it comes to analog broadcasting, yes, it is. Signal piracy is possible. When it comes to digital broadcasting, the signal piracy is not possible. The next slide will tell you why the signal piracy is not possible when it comes to the digital one. The 4G peer-to-peer live streaming is concerned. It is a TCP UDP model, transfer control protocol, and the user-defined protocol model. Over the internet protocol, you have a IP7 layers model. You have to put it in that. Then there is an encryption and decryption one. You don't have to worry about the piracy issue in this context. So internet transmission is an internet transmission. It is not a broadcasting, the technologies. It's based on the streams, and the piracy of streams are not possible in this context. So economic analysis, the previous one is about the technological analysis. Now we are moving to the economic analysis. The analog signal, it's an outdated technology only in few jurisdictions in Africa and Asia. It was estimated by ITU, International Telecom Union, that by 2020, analog mode of transmission would be completely eliminated from the globe, but it has been substantially achieved, except very, very few jurisdictions. A signal piracy is much possible and persists in the analog broadcasting context. Investment requirement was extremely high. when it comes to the digital signal context benefit to both users as well as the broadcasters, it's highly penetrated in the globe as of now. High-end encryption and decryption. Because of this, signal piracy is complex and time-consuming, and by the time the content would be available in some other form and made available to all. So when the cricket match is happening or when the football match is happening, what is important for you is who is winning the match, what is happening at the last over. Last over, last ball. So what will happen? I know I can get the news, but I want to see that. I want to enjoy that particular moment. So that is the, that's the induction for everyone to see the content. So time is most important aspect in this, the factor in the broadcasting context. Whereas the 4th generation peer-to-peer live streaming is concerned, it's a IPTV slowly getting into momentum in the Indian context, which employs at least a 64-bit or 120-bit keys, encryption techniques. Keys are nothing but encryption. Now it has gone to 256. Even at the defense, the national security purposes, government of India is also using advanced bits also. Internet, it is a minimum of 64-bit, 128-bit. WebTV is also, available. The investment required for all these, the live streaming related techniques, its investment is substantially low, considering, the broadcasting techniques. What you require is you need to have a sophisticated equipment and a high-speed internet connection. So in this technological and the economic analysis, when we examine the evolution of authors' right of broadcasting, the Broadcasters Organization Protection historically, as I pointed out, the Berne was amended in 1918 and 1948 for the purpose of incorporating radio broadcasting and the television broadcasting respectively, which was addressing only the concern of the entertainment content. It was not addressing the concern of the signal piracy, which was taken up by the Rome Convention and provided protection for the broadcasting organizations subject to the permission of the authors. So it provided very limited protection under the TRIPS. So Rome and TRIPS are adequate to address the existing problem of the traditional broadcasting, because the signal piracy is only possible in the traditional broadcasting. I'm not saying that there is no piracy with respect to broadcasting. I'm talking only about the signal piracy. The signal was being pirated, that was the concern. Now, the piracy is rampant in the broadcasting. Those piracies are not related to signal, they are content related. If it is a content related piracy, the content piracy can be addressed by the copyright law. If it is a signal piracy, then that has to be looked at. Whereas the traditional broadcasters are concerned, signal piracy was rampant in that point of time. There are various studies available, and they emphasize for providing protection to the traditional broadcasting organization within the copyright framework, which was not taken up, not supported by the authors. At the later stage, it was taken up by the Rome. As far as present scenario is concerned, in the advanced technological era and the advanced encryption, encoding is there. At the later stage, even for the analog signal, encoding technology was introduced. Now we are in the digital and the internet-based transmissions. We don't require this type of the old technology. So we have moved out of that. Now we are having sophisticated transmission modes with high encrypted content. And decryption key is also much, much complicated. So that's no signal piracy, only content piracy. And one can conclude in that particular aspect, there is no point in looking at this, the legal gap in the advanced technological era for the broadcasters. So author's right of live streaming is concerned, yes, it has, looking at the international development, it is the practice of the Berne Convention, the international practice, as and when the new technology comes. The copyright law will be suitably amended and the technology will be included. It is not only in the Berne context, it is in the Indian context as well. And it is only in the United States, in the subsequent slide will tell you, it is only in the United States, it will be automatically extended through judicial incorporation, because the definition given there is open-ended, whereas the Berne definition is a techno-specific, the Indian definition is also techno-specific. That is the reason why the Indian Copyright Act has been amended suitably at various points of time to incorporate many technologies that have come up in the market for the commercial exploitation. TRIPS does not provide any kind of technology related issues in the live streaming context, because 1994 the technology was new. 1996 WCT did not take up this particular issue because 1996 period the live streaming technology was not so at peak, and it was not commercially exploited at a higher level in many developed countries. It was not. So that was the reason why WCT did not provide. If you read Article 8, it was not clear. The language may be open-ended. It was not. Later, it was the WIPO guide to the WCT Article 8, which paved the way for the expansion by using the flexibilities provided in Article 8. In this context, since 1998, WIPO has been deliberating on this particular issue. It is more than 20 plus. What they actually do, the issue has become redundant, but the process is ongoing. The issue has been completely addressed. Now, we are worrying. People are looking at this, television industry. The revenue has gone completely. People are now moving towards internet-based, entertainment contents. Now they are bored with the traditional setup. They are not interested in watching the content. Look at the revenue. Top media, industries, CEOs have come up with the statement that revenue through advertisement is going to be down, and it is going to be historic down. It's not because of the pandemic. It is because of the behavior pattern of the people. So this is the position in US. US does not provide any protection to the broadcasting organization. It provides protection only to the authors. So whatever you want to do, the broadcasting organization have to approach the authors and get permission. Then whatever you want to do, it is like a contract type of arrangement. Whereas Europe and UK is concerned, they provide special protection. It is through judicial pronouncement, they have incorporated this particular technology into their law. As far as India is concerned, the Indian law is also, it's not adequate enough to take care of the live streaming, because the 2012 copyright amendment is also not addressing this particular issue. It did not take up because live streaming was not known to the technology. 1996 WCT aspects have been taken up by the India only in 2012. So we cannot expect a 2012 amendment had addressed this concern. Probably we need to take up this particular issue in the coming issues. So due to technological advancement, signal piracy issue has become redundant. Only content piracy is on. Live streaming is a different technology, hence no expansion of broadcasters' right is justified. In this particular context, I conclude by saying the future is all about the internet and internet-based transmissions. We have seen the death of our slowly, slow poison type of, theaters are going to be out of the picture. Similarly, we are expecting the television is also going to be out of our life cycle. And we are moving towards different type of entertainment contents. Now people are more towards open access model. That's what I said. Now the cuckoo song has been gaining momentum. Now that flows, that ensures there is a revenue flow. People are putting things in open access model and enjoying it. So with this, I thank the organizers, especially Dr. Lucky Judge and uh, Dr. Sunil Gatsan and Dr. Arati and Dr. Binda and other organizing committee members for providing this opportunity. Indeed, it's my pleasure to share with Professor G.B. Reddy and Arati Ashok and dear brother Gopa and dear brother Kadavan. Thank you very much.
Thank you very much, sir. Thank you for your insightful thought and deeply analyzing broadcasters' rights in the digital era. Quoting the provisions from Rome Convention and Agreement, and also about single piracy and selective piracy, and authors' rights of live streaming, and about WIPO internet traders, and also about the position in USA, UK, and India. Thank you so much, sir. Hope all the participants would have enjoyed this session. Next, we'll move on to the next speaker, Ms. Aarti Ashok. Madam is an assistant professor, Department of Intellectual Property Rights in QSAT. Madam passed LLM with specialization in intellectual property law and labor law from the School of Legal Studies, Cochin University, with the second rank from the university. And Madam has worked as a research officer at MHRD, chair on IPR in Cochin University, and worked as assistant professor at HNLU Raipur. And Madam has edited books along with Anish Pillai, cyber laws, issues and concerns. And Madam has written articles and chapters in various books. And Madam has participated as a resource, and she has done more than 42 presentations and as a resource persons and invited lectures. Madam is a, am I audible?
Yes, yes.
Sorry, I faced some technical problems. Sorry. Madam has presented papers in various national and international conferences in commoditization of health, from TRIPS to RCEP, biotechnological inventions and farmers' rights, and so on. We are very happy to have you here for our session today, Madam. Over to you.
Thank you. At the outset, let me express my gratitude to the Dr. Ambedkar Law College for having invited me, and also to all the organizing team, particularly Lucky Ma'am, who has invited me to the program. Now, I'm just sharing my screen. And again, I should start that the theme that has been given to me, which is on e-learning and copyright, is quite different from what we have been hearing till now. The first lecture, the keynote address by Gopakumar sir, he has emphasized on public interest, access to vaccine, and how it should be made easily available. The second talk, when we moved on to Dr. Shaktivel, we saw his emphasis on private right, actually. We had the users on one, the authors on one side, and the broadcasters on the other side, and they making available to us resources and how they should be protected and what kind of protection is needed. But essentially, we were talking about a private right of either the content creator or the person who's investing to ensure that those content reaches us. But taking you away from the private rights, I am moving on to a more public right regime where copyright provides a mechanism and also can prove to be an hindrance on providing one of our most essential rights, a fundamental right in that sense, which is education. So it's for the sake of convenience, it has been titled e-learning and copyright. But the premises on which we are going to move is basically our right to education. Now, undoubtedly, And again, at the outset, let me put it that all our laws have been drafted in the pre-pandemic era, and then in 2019 we were hit by this wave of coronavirus, and we are trying to accommodate ourselves to the new normal, trying to accommodate all our existing laws into the new reality, because our reality have changed considerably. So the same holds for even copyright, the law that has been made in a pre-pandemic situation and a new reality that is posed by the pandemic, just like our constitution is. Now, when we are talking of our rights of education, undoubtedly, education is the fundamental right that all of us have if we need to build a better society. And the right has been stated in Mohini Jain, but let's not go into the very narrow sense of how the Constitution understands it as a mere free education for a age group from 6 to 14. But let's talk of education at a much larger sphere of having a right to learn, to get knowledge, not just at primary or secondary level, but at higher education. I'm not on a ground of posing a responsibility on the state, but stating that we have a right to such an education. And of course, our education, we have a lot of public institutions, we have a lot of private institutions to cater to this. And this right is not something that is recognized solely within our constitutional framework. But if we look into the international domain, we see its equal recognition at all international platforms, the latest of it being the Sustainable Development Goals, goal number 4, which talks about quality education. And again, education is not something that's limited to primary or secondary, but higher levels of education. And in an era where we are dealing with technology and where if we have to survive, we require not just basic knowledge, we require technical education. And it's that technical education that would make a difference as a nation also. And if we look into the basic international documents, both UDHR and ICESCR, the Economic, Social, and Cultural Rights, the International Convention, both talks about education as a basic human right. Now, if you move back to UDHR, it's not just that education is seen as a basic human right, it also talks about IP or intellectual property in a large sense. And it's very interesting to note that IP, not only from the private right point of view, but also from the public right point of view. More importantly, the public right is emphasized in UDHR. And like I said, all of them, the rights establishing documents that we have primarily are the pre-pandemic era. And then we move on to the digital, or we moved on to the digital era. In the previous presentations, Shakti sir was mentioning about online education or virtual education becoming a boom for the industry right about from 2015. Now, practically most of us would have started accessing e-learning or understanding technology as a basic requirement for our educational facilitation, probably by the onset of pandemic. But if you look, the platforms that provide education, particularly the online content providers, have been there for quite some time now. Now, the access to education today in the pandemic world, or what we call the new normal, is being made available through a lot of platforms. And interestingly, most of these platforms, or at least most of the platforms that we use, are not being held by Indian companies. They are all foreign in that sense. So technology is being developed elsewhere and is being used by us. So I'm not sure which is the platform that your institution is using for the regular classes. I believe it would be Cisco. We at QSAT are using Google Classroom. So we have a range of platforms which technology has today permitted to let us interact with our students and communicate to them on a one-to-one basis as if we are on a regular face-to-face, or what you call the old situation of classroom teaching. So that is one set of technologies that has come about, which facilitates this online class face-to-face interaction, ensuring that teaching happens at the most, let's say, normal or the old normal situation being brought back. It's not, though I have just written these platforms, there are also TV channels. Again, my knowledge is limited to state of Kerala in that sense. There is a channel called Victors where you would have a timetable and classes are recorded and being telecasted. It's primarily for the school, not applicable to higher education. So every class, all subjects are being taught through TV, which has a much higher reach than internet in that sense. Apart from the facilitation platforms, we have a lot of content providers also. And most of these content providers, if you note, they are not actually, they did not come up as a consequence of the pandemic. They all existed in the pre-pandemic era, be it e-Pathshala, which began in 2015, Swayam, which started in 17, Byju's app, which is a private sector, the other two being governmental initiative. Then we have the databases that we have been using. Now, the difference is that in e-Pathshala, Swayam and Byju, they actually are the content creators. They are not just the people who transmit the content or make the content available in that sense. They actually are the content creators. On the other hand, you have the Gestor or SSRN. They are databases where they don't create content. They compile the content, assimilate the content, and make it available for us, sometimes at a cost, sometimes free. JSTOR is a paid database, which means somebody has to pay for it. So it's probably your institutions that pay, because it's very costly in that sense if you have to individually subscribe to it. SSRN, on the other hand, you have a free database. And then, of course, the broadcasting organizations, which Shakti sir did mention earlier, the mechanism that makes us get access, the service providers, the other kind of facilities, the net connection, all that makes possible me sitting in Cochin and you sitting elsewhere and having this discussion. So most of these, again, some of these or most of these came before the pandemic era. So, but the market grew much, much exponentially because of the pandemic, because we have been restricted to our homes and our education or the college has to come to our home because we can't go. So this change in situation has created an unrest in the existing law, the law that has been created for an otherwise analog environment. There are multiple laws that come into play. For the scope of our discussion, I'm just taking up the Copyright Act. Now, copyright, just running through very briefly, you are familiar with all the works. Now, from being a teacher, all these works are used in a classroom, particularly when I'm teaching intellectual property. It's very easy to communicate certain things by showing them a video. Sometimes it's music, particularly to teach copyright infringement. Sometimes it would be photos or drawings. So all kind of works are used in an academic environment. I'm talking from the user point of view, not the creator point of view. So from a user's point of view, we are using all these kind of works without actually looking into the copyright angle of it, because we believe from a classroom perspective, it's quite okay to use. But then undoubtedly, all these have set people from whom you have to get a permission if you are otherwise not permitted by the law or under a contract, whichever the case be. Now, the reason why we as teachers or we as students and researchers use this right is, again, going back to the private right initially. Copyright, if you understand it as a private right, these are the rights that are vested, which are very clear and distinct, particularly in an analog sense. If you ask what is reproduction, it's taking copies. Photocopy is a classic example of reproduction. What is communication to public is, let's say, reciting a poem to a crowd. And distribution is distributing the series of a movie. So you have distinct activities where you can identify each of it. And this is very clear in the analog context. But the problem is when it is being tried to apply in the digital context. And we'll come to those problems, particularly in relation with education. Now, to foster education, the Copyright Act as such, what we see today, 2000, as amended in 2012, do provide certain provisions in fostering education directly. And all of them might not be equally applicable in case of, or equally significant in case of a online teaching scenario. Some of them might have a much higher stake than the others. Now, the first is publication of majorly a set of non-copyrightable material. So that again, practically you don't find a lot of litigation in all this. Probably the litigation part, Kadwan sir might take it up. But the second part, where you have the reproduction of the work by a teacher or a pupil for the course of instruction, this is something which as teachers and students, we very constantly use. The amount of photocopy that we take, and cover to cover, it's not even just a chapter that you might be taking. At least here, I know students taking books cover to cover. We download a whole article. So in education, as long as it's for the purpose of education, Indian law has never restricted on the quantity of the work that has been taken. Unlike certain jurisdictions where there is a specific understanding that only 20% of the work will be taken or 30% of the work will be taken, in India, we don't have such a set norm. Judiciary has never moved into those lines of saying, so whatever is required for your purpose of education, you can reproduce. But then I call on your attention to the word reproduce, which is very clear in the analog context. And again, in performance, on the next provision, where you can have performances by the students or the members of the institution, for the audience also being students and members of the institution itself. So it's a closed room in that sense. And in that, performances can happen, which any kind of performances, particularly cultural performances, where we might be using musical work, we might be using sound recording and cinematographic work particularly. So all those within the academic atmosphere is permissible. Now, this being the existing law, we look into how the scenario changes when we are trying to pull in what we call as online education in the context. Now, while we are in the online education mode, undoubtedly, the first problem with the online education is students and teachers do not have access to our libraries. So that is the first problem that we face as a researcher, that you do not have immediate access to your library, because most of our library are in the analog setup. Very few institutions would have a commendable digital library. Now, we might have access to digital databases, but in the earlier situation, undoubtedly, the databases also used to be through IP access, which means you need to be inside the campus to access those databases. So one thing which every institution almost already did or immediately did was to make IP access, take IP access out of the norm and give the access to digital library, whatever they have as digital or databases, to the students who are at home or researchers who are elsewhere. But the problem still remains of non-access to library. We'll come to the non-access to library a little later. And if the library facility is not available, then the responsibility becomes on the teacher to provide adequate material for the students. So apart from the classes that happens, every teacher might be required to provide some kind of additional material. And the question is, can the teachers be circulating materials for the students on the platforms in which classes are happening? Now, if you go back to the exemption which is provided under 521I, which talks about reproduction, which was very clear in the analog context. But when it comes to digital networks and transmission of work using network, you have the activities of reproduction, communication to public, and distribution mingled and fused as one. So when I am actually sharing my slide, which is on my system, it makes multiple copies and then gets converted and at the far end reaches to your screen wherever you are. So there are multiple reproductions being made. At the same time, it is being communicated. It's not just being reproduced. The work is also being communicated. I am not sure if your technology permits you to download, but then if it permits you to download, then you can download a copy which amounts to distribution. So in the internet context, the way the technology works, you do not have a hard and fast a determination or a clear cut understanding of what is reproduction, what is communication to public, and what is distribution. They fuse into one. And the law says that only reproduction can be done under the classroom environment. So it undoubtedly can be extended to the classroom environment, but the activity can only be reproduction. So the question is, these are some things that I do in class. Like I said, we use Google Classroom, and I share textbook with my students in Google Classroom. So they can read the text. I have enabled in such a way that the textbooks they are not able to download, but then other materials that they are able to download. So am I within the protection of 52(1)(j) when I am sharing materials to the students whom I'm teaching a particular subject, because they don't have otherwise access to library. So it's their right to education and my duty to provide it. But then am I on the right side of the law or not? Second is it should be in the course of instruction. Now we had, all of you might be familiar with this case of what is commonly called as the Delhi University photocopy case, where it was again regarding the hard copy books. It was spiral bound course material in that sense. But in interpreting the course of instruction, the code was very clear. Course of instruction does not start with during the classroom. The interpretation was essential because if you look at certain other laws, particularly in US, the educational exemption can be claimed only for activities that actually happen in the classroom, which means you have a 1 hour class, the activities that happen during that 1 hour would get excluded. But if I send a material to my students today evening for tomorrow's class, that might not be excluded under the US law. So they have a very, very narrow understanding of classroom exception. It's called a classroom exception. But in India, the language uses in the course of instruction, and the Delhi University has, the Delhi High Court had given a very wide interpretation for this term in the course of instruction, covering all aspects where you, when the start of a course, even including its syllabus preparation to the end of the course. So in that sense, owing courtesy to how the Delhi High Court has interpreted it, it's not just the class hours or communication, because most times, particularly for online classes, if work has to be assigned, teachers communicate students around the clock and students communicate to teachers around the clock, because you might not have a fixed timetable anymore because everyone is at home and you take classes at your convenience. The question also comes in relation to people who are doing distance education or online education, where you might be engaged in a job, regular job, but then you are taking up some kind of an education like this YM platform where you can upgrade your skills, or any other platform which lets you upgrade your skills. So in understanding course of instruction, thanks to the Delhi High Court, we have a very fair understanding of what it could be. But the problem of reproduction still remains. Now, practically, another section that can come to our rescue, a rescue of any teacher or a student, is 51A, which deals with fair dealing. Now, fair dealing, again, this is a newly introduced language of 2012. It uses both the word private or personal, which means that private and personal can be seen as two different. The earlier understanding of private use was I could do something for myself and myself alone. And now the new usage of the term personal, it is being understood a little wider in saying that it might not exactly be for me, but it could be for some other person also, but then who's into a personal relationship with me. For example, I could do a fair dealing activity for my child or for my parents. They might not be the person who are doing it. I might be the person who's engaging in the activity, but still would get a protection under 52(1)(a) as fair dealing. The question is, can this be extended to my set of students? Because under 52(1)(a) in fair dealing, it is not restricted to reproduction. Any activity can be done. So would private and personal use include my set of students to whom I might be sending material? So if I am not protected under 52(1)(i), which is specifically for education, can I claim a protection under fair dealing of 52(1)(a)? So these are the gaps that we find in the existing law. Now, when we look at the international position, Berne Article 10 has a very specific provision which deals with education. It's for teaching. And it says that publication, broadcasting, sound or visual recording for teaching, provided such utilization is compatible with fair practice. So as long as your intention, your practice is fair, it is education, there is no other restriction imposed by Berne Convention. So the technological difference of being online or offline. Burn is technology neutral in that sense and can be used in the online context also. It's a similar case with TRIPS. TRIPS lays down what is called as the three-step test, and every state or every member party can make exceptions so as to facilitate whatever is their domestic requirement and technology neutral. So these are the international provisions that we have in front of us. And we look into the 2002, it's called the Teach Act. This is the American Copyright Amendment, which actually brought in to ensure that online education happens. So this is also much before the pandemic, and they were prepared with a law, probably because digital education was much common there. So they needed a law to regulate it. But then what needs to be understood is that Teach Act is very restrictive. It does not cover all subject matter, like all works are not covered in the Teach Act. Similarly, the full work also cannot be covered under the Teach Act. So it's only some part of the work which can be transmitted. So if a full book is required, and let's say literary work is permissible under the Teach Act, the full book cannot be transferred to the student. There is a restriction on the quantity that can be transmitted to the student. So there's an inherent criticism within the US itself that the Teach Act is inadequate to deal with online scenario. And they also, just like us, depend on the normal fair use provisions. They have what I call a fair use provision, just like our Fair Dealing Act. So this is how the scenario remains in the international platform, and I just took US as an example. Now, when we come back to our particular law, the problem is that, like I stated earlier, our laws are the pre-pandemic, and we did not have the foresight while making the 2012 legislation, the 12th amendment, probably because the technology was not there, and we never envisaged a situation where education would be thoroughly online. So because of that, we find we find a very huge gap in the law, in the language of the law, though education per se is already present in that. Now, coming back to the problem of your lack of access to library. Now, in the present act, under section 52(1)(o), the present law, there is a provision that the libraries can digitize all the content that they possess. So if provided they have a hard copy. So all the hard copy they have, they can digitize it and maintain a soft copy format. But it has two core problems. Firstly, converting hard copy to soft copy, it's what you call, you require huge human resource to do it, depending on the size of your library. Cochin University SLS has a very huge library. So our librarian never took up the pain or has not started converting this into soft copy. And the bigger problem is, once the work has been converted into soft copy, can the soft copy be lent to students? Because the whole purpose of the library is to lend books to students. Should it be concerned with the format? So if soft copies could be lent to students, then there could have been some mechanism in which it could be made available online also. But the problem is, the problem that technology poses again of multiple copies being taken. The problem, you can't restrict the technology. And of course, if it goes unrestricted, on the other side, the author or the publisher, they would have a huge loss in the market because every student might have a copy of the textbook. So you have a problem of lack of clarity as to whether the digitized books can be lent by the library to students. If that is possible, what are the ways or what are the safeguards that a library needs to have? In all these, there are absolutely no clarity. And then again, we need to understand that in the online context also, as in the analog context, a student has all the other freedoms for his education. For example, when we take a book from a library, it is within our right to take a photocopy of whatever is required and retain with us before giving a copy to the library. So that is undoubtedly a part of the user's right or a fair use or a fair dealing right recognized under the Indian law. Now, when we make or if we try to make new reforms in our law to suit to the digital needs or the online teaching needs, these traditional freedoms should not be hampered. So as a student, if I have a right to take a photocopy, I should also have a right to retain a copy for my educational purpose. So it becomes a huge act of balancing, a balancing between the rights of students and researchers on one side and the rights of the content creators, the authors, and their intermediary, the publisher or whosoever is on the other side. So undoubtedly, the law needs a change because there's a huge gap in this law in this regard. And when the law is changing, emphasis should be given to the user's right. Because if we create a law or a copyright mechanism in such a way to hamper education, then the whole essence of the law fails. Undoubtedly, the private interest of authors needs to be protected, but it should never be at the cost of the user's right. So it's just open thoughts, but I think these are the ways in which the law has to change. So with that, I come to the conclusion and open for questions. Thank you.
Thank you so much, madam, for the topic, e-learning and copyright.
Ma'am, you're mute.
You are mute.
Yes, I'm sorry. Can you hear me now? Yes, thank you. Thank you, Arati madam, for sharing the session with us. The wonderful topic, e-learning and copyright, which is a need of an hour, not only for the education institutions as well as for the students in the current situation where everyone are learning from home. And you have very well covered about fostering educations, issues in online context, international provisions, the three-step test of trips, and about the Teach Act US and reforms in India, and role of library in creating digital version and access to students, and insisted on the change in law to have balance between creators' rights and users' rights. It was a very helpful and useful session, madam. Thank you so much. Now we have come to the end of the session, today's session. Due to unavoidable circumstances, we could not have our third speaker, Advocate Binoy Kadavan. So we regret and sorry about it. And I request Dr. Brinda Madam, Assistant Professor, Department of Intellectual Property, to deliver the vote of thanks.
Thank you, Aarti.
Yes, Madam.
Good afternoon to one and all the speakers, the learned colleagues, and the participants of this wonderful workshop. First of all, I extend my heartfelt thanks to our Honorable Vice Chancellor, Professor Dr. N.S. Santosh Kumar, sir, for delivering the wonderful presidential address. For this workshop, a good start is a half success. So, sir's address leads to the workshop to start with positive progress. Thank you, sir. I thank Professor G.B. Reddy, sir, for his inaugural address. Sir's lecture is an insight upon the theme of the workshop, COVID-19 and its effect on IP. Thank you, sir. Now I want to thank Mr. K.M. Gopakumar, sir, for his lecture on detailed research upon the vaccination and how IP is involved in the production of protection and production of vaccinations by way of patent and trade secret. And also we come to know the critical situation of India, why, as we are very much lagging in production of this vaccination. It was a very detailed research. Thank you very much, sir, for sharing your research thoughts on this workshop. Next, I thank Professor M. Shaktivel, sir, to deliver a lecture upon this broadcasters' rights on various aspects. His detailed lecture gave a greater insight on the topic, even to a person who does not have a basic knowledge about intellectual property rights. So it is a very detailed lecture, and everyone can easily understand what sir's conveyed. Thank you very much, sir. And I thank Professor Arati Ashok, ma'am, for her wonderful delivering of lecture on e-learning and copyright. And now there are so many student participants, they will be knowing that what is the creator's right and the user's right, and what extent it is permissible to use this online platform while using the materials, while what we get it from online resources. Thank you, Arati ma'am, for this wonderful lecture. And finally, I extend my thanks to all the student participants, without whom the workshop could not be this much successful, and our colleagues and our beloved Aarti Ratna for wonderful comparing of this wonderful workshop. And from the beginning, and it is not only the session, but also all the works, the primarily what we started with from preparing the invitation onwards. So her contribution is very much. Thank you, Aarti. And I thank Sunil Clarkson sir and our HOD Lucky George ma'am and all the participants of this wonderful workshop. Thank you for making this workshop a great success. Thank you all.
Thank you so much, ma'am. And I add one more person to this vote of thanks. I thank Assistant Professor Rahul Raghu sir for making the brochures for the program. Thank you so much. Thank you all the speakers, resource persons. Thanks for being with us today.
Thank you.
And yes.
Aarti, you're in mute.
Oh, some problem. Ma'am, did you hear when I spoke about Rahul Raghu sir?
Yes, yes, yes.
Yes, Aarti.
Thanks.
Thank you, Raghu sir.
Yes. Feedback form is posted in the chat box. Yes. For those who are connected with us through WebEx, and in the description box for the participants who are connected with us through YouTube. Feedback forms will be open for the next 20 minutes. Certificates will be sent within a week's time. Thank you once again for being with us today. Thank you. Thank you all.